On today's episode of the Lantec Link podcast, we are going to discuss legal implications facing manufacturers today. So to do this, I have Aaron Prenger, who is an attorney at law for Spencer Fane and deals specifically with manufacturing professionals. So what he does, he pretty much busts open any contracts or legally binding documents that you've got, makes sure that the language in there is protectant of you as a manufacturer and business to try and keep you out of court as best possible. So regardless of, if these are contracts with customers or even employment documents, his goal is to cut down on any liabilities that you may have as a manufacturer and keep you out of the courtrooms. I'm going to go to a short break here, and then we'll get started with Aaron's interview. Stay tuned. Hello and welcome to the Lantec Link podcast, linking manufacturing professionals with industry experts. I'm your host, Kevin Must from Lantec Systems, and today I'm joined by Aaron Prenger, attorney at law from Spencer Fane, to discuss some of the legal implications that manufacturers may face today. Welcome to the Lantec Link podcast, and thanks for taking the time to speak with me today, Aaron.
Absolutely. Thanks for having me, Kevin.
So, before we jump in here, we'd like to kind of give our listeners a little bit of a background of yourself as well as Spencer Fane. So if you could just tell our listeners your educational and professional background and kind of what led you into becoming an attorney at law for the manufacturing sector.
Sure. So I had a little bit of a strange path to get where I'm at. I actually started out of undergrad from the University of Missouri. Go Tigers. And I started as a banking career, which I spent about 10 years in, and decided that wasn't for me, went back to law school, and ended up working for Spencer Fane as a summer associate through law school, and essentially started with that summer working with various manufacturers, distributors, fabricators, service-related clients. One of the senior partners here kind of took me under his wing, and I continued to work in that sector and for him through my last year of law school, and came to work for Spencer Fane right out of law school as well, or continued to work for them, I should say. And I've been representing various manufacturers, distributors, fabricators ever since. Spencer Fane is a full service, it's what's considered a medium-sized law firm, although that's maybe a bit of a misnomer. We're primarily a Midwestern and Southwestern firm. We have offices in about 19 different cities, I believe, at last count. And we serve all types of needs. So, a lot of my clients come to me for the terms and conditions type work that I do, but a lot of them also come to me with employment-related questions. We have a very robust employment practice. And so, any kind of human resource issues or, lawsuits regarding employees or those type of things I help out with as well. We have a robust intellectual property practice as well. So I have several clients that I help with those issues, including manufacturers and fabricators, helping them get products patented or navigating that type of work. So we really do just about everything. The clients that we represent tend to use us for as their primary outside counsel and for a variety of different issues. But personally, my focus in the work that I do is in the day-to-day type operations of the manufacturers and distributors.
Cool. So how long have you been with Spencer Fane yourself?
A little over 5 years now, or right around 5 years, I guess.
Nice. Is that including your time through school as well?
So I was the old guy in law school, and I do think my 10 years in the banking industry gave me quite a bit of what turns out to be relative experience as well. Mm-hmm. Just understanding different things about, real estate and finance and things that impact nearly every business. So I think that's really helped me quite a bit. But it's been about 5 years as far as practicing law.
Yeah, I think coming from that banking side too, that helps with a little more of a maybe business orientation or a little more business minded, as opposed to just strictly legal. You're looking at it from how can I better advance these manufacturers through terms and conditions or anything like that, and try my best to keep their costs down as well.
Well, absolutely. I think when you come straight out of law school, you don't have a lot of real world experience. You've been taught to think about things like a lawyer and in a very specific Socratic method type way. And while that's very helpful in many aspects of the law, it can hinder your ability to effectively represent your clients when you're constantly thinking about the legal issues and the legal aspect of things. What my clients want is they want somebody that understands business, that understands their business, that understands the problems that they face day to day, which almost never seem like or feel like legal problems. And so yeah, that's one of the things I pride myself on, is having that kind of perspective. And if I can talk to a prospective client for 30 minutes or an hour about their business and they never find out I'm a lawyer, I feel like I've done pretty well.
Yeah, I'd say that's a win. Well, and I mean, that's kind of something that we're seeing too in the manufacturing realm as a whole when it comes to, the kind of skills gap and stuff is in school. You can learn so much about theories and applications and how to, best calculate different measurements or different aspects of manufacturing. But until you're on the shop floor and actually put it in practice, you're kind of, I don't want to say no good to people, but you don't have that rich experience of how to operate everything from front of house to back of house and everything in between.
Yeah, absolutely. It's not hard to find someone that can tell you what the law says, that can properly research an issue or read some cases. That's not what my clients want. My clients want somebody that can help them solve problems.
Yeah.
So that's the way I look at it. If you've got a problem, let me try to solve it. My legal background, my banking background, my real estate background will absolutely come into play and hopefully give me a unique perspective that a lot of my clients don't otherwise have.
Yeah.
But really, it's about solving problems and doing so efficiently. And you can't really do that unless you can say, well, I've encountered these problems before. I've seen this with other similarly situated clients. I've seen this with very large manufacturers. I've seen it with very small manufacturers. I've seen it with medium-sized manufacturers. All the experience is critical in knowing how to assess a situation and solve a problem.
Yeah, definitely. Okay, so before we jump into some further legal issues that may be facing manufacturers today, what kind of hobbies or anything that interests you that is kind of out there, a little wacky maybe, if any?
Wacky hobbies. Oh, I wasn't ready for wacky hobbies.
Yeah.
I've got 3 kids, 7, 3, and 1. So I would tell people that I play golf, but I get out there about 5 or 6 times a year, mostly in scrambles and different sponsored type events. Right now my hobbies are basically changing diapers and making macaroni and your basics, playing some baseball now finally as the boys are getting a little older.
Yeah, it's having a 7-year-old, you're being able to play some sports, I'm sure, with them a little more, maybe even turn them on to some golf. Who knows?
We're trying.
Did you have a chance to play in that FMA scramble at the annual meeting?
I did, yeah.
Nice.
Yeah, it was a lot of fun. We didn't do very well. We had a problem rolling putts, but
yeah,
we had a lot of fun.
Yeah, that's the thing with scrambles. It's just about having fun, kind of networking, getting to know some people. We didn't do so hot either, but I had a good time. The weather was great, and the course was beautiful, so can't really beat that.
Nope.
All right, so this takes us into the main content for today. Again, this is legal issues that are facing manufacturers. So, in your opinion, what would you say are some of the biggest legal implications that manufacturers face today?
Well, one of the main things that I work with my clients on and that seem to slip through the cracks and don't get as much focus as it should is terms and conditions. And when I say terms and conditions, I'm talking about the terms and conditions in your purchase and sale agreements, your supply agreements, but also other documents that you may use, confidentiality agreements, non-disclosure agreements, demo agreements, lease agreements, whatever type of documents you may have between the entities. I've found that terms and conditions is one place where a lot of manufacturers don't put a lot of time, don't put a lot of resources, and it can be problematic.
Yeah.
What do they say? Are they consistent with how you do business? More importantly, do you understand them?
Yeah.
I find that a lot of companies, they feel like, oh, that's just the legal mumbo jumbo. It'll all be fine. It's kind of like when you click to get to the next screen for an app or whatever you may be doing online nowadays. I accept. Nobody actually goes in and reads those things.
Yeah.
And as a consumer, you have certain protections that are built in. And so while I don't advise signing or clicking or agreeing to things that you do not read, as a consumer, there are at least certain protections that are out there that keep companies from being overly, from gaining advantages on you that they shouldn't have, basically. Okay. But in the business world, the law does not work the same way. The law is going to say that business people are savvy, that they understand things, that they read what they sign. And there are not as many consumer-style protections out there that will protect a business who gets himself in hot water by signing a document or agreeing to terms and conditions that they don't understand.
Yeah. Yeah.
So one of the things that I'll talk to my clients about is I'll just ask them about, let's take a look at your terms and conditions. Where did these come from? Did you hire an attorney to do this? Did you Google a bunch of documents and slap together paragraphs, which, believe it or not, turns out to be an extremely common way that a lot of companies put their terms and conditions together.
Yeah, I could see that.
And so we'll start asking them about that. Is this consistent with how you do business? Oftentimes, your terms and conditions say one thing, but your actual practice in how you run your business may be different. And that can be problematic. I ask them about the contracts that they sign, the purchase and sale agreements they sign when it's somebody else's document, when they've drafted the terms and conditions. Do you understand what you're reading? What can you tell me about indemnification? What can you tell me about the limitation of liability? Are you subjecting yourself to consequential damages? What about the insurance requirements? Are you sure that you've met all those? Is there anything any place where maybe you haven't quite met those requirements? And what you find is that a lot of people don't really understand all these. They want the business. Somebody's trying to buy their product. It's a large sale. It's a large deal. They want to make the sale. So they don't take the time to understand the terms and conditions. And, ultimately those things can come back and bite you.
Yeah, definitely. And I mean, do you feel that you were saying just kind of some copy and pasting that you see a lot for terms and conditions? Do you feel it's kind of a mix of with how busy that they are trying to bring in new business that they don't think that it's that big of a deal until it kind of comes back to bite them? Or do you think it's just they've kind of fallen complacent to old contracts that, may be out of date given our technological landscape and how everything kind of operates now as opposed to 20 years ago?
Well, I'm sure it's some of both. It really depends. A lot of people call me when it's too late. They call me after they've had a problem and after they've got themselves in a dispute. And this other party, which oftentimes might be their customers.
Yeah.
Nobody wants to be in a dispute with their customers. Nobody wants to sue their customers or be sued by their customers. But oftentimes it is. And so I'll get the call once they're in a dispute and they'll say, hey, they're telling me that I have to do this or that I agreed to this. Essentially they're acting like they really have the upper hand in this dispute. And we want to know, is that true? And of course, most of the time it turns out to be, because what's happening is other companies, especially large companies, especially a lot of your buyers, of manufacturers or fabricators, especially if you're a fabricator of parts, these major buyers, the large companies that you're doing business with, they change and adapt their forms all the time.
Yeah.
And when they're updating those forms, they're doing it because, maybe they got burned. So they're going to button up that loose end.
Mm-hmm.
They're adding language to increase their advantage in the instance you get in a dispute. They're looking to push liability to your side of the table and away from their side of the table. So they're shifting the nature of the relationship. They're shifting the nature of the sale. And people, if you're not responding to that, a lot of people are just signing the same document. Once again, this is what I need to sign to get the sale. I'll sign it. But if they've been updating their forms and their forms have been, growing into the type of things that will give them advantages and will shift liability away from them and onto your side of the table, shouldn't you be charging for those things? I mean, shouldn't you be adjusting your pricing for those type of things at the very least? Because they're asking for more. They're no longer just asking for this part or this product. They're asking for this part and this product, plus they want you to take on X amount of liability, plus they want to put you in a position of disadvantage to the extent there's ever a dispute so that they can essentially make you do whatever they want you to do. Those types of shifts, those types of add-ons to what they're buying should be reflected either in the price or in the response to their terms and conditions.
Mm-hmm. Yeah, I would think. Oh, go ahead.
I was going to say what happens is that it ends up to where you're taking on too much risk. Either if it's because the indemnification provision has language in it that expands beyond its intent or that expands beyond the insurance coverage that you have. Mm-hmm. That's one of the most common, by the way. Indemnification is a word that as soon as I say it to most of my clients, you kind of see their eyes glaze over and they don't know for the most part what it is.
Yep.
And
it's about where I'm at right now.
Yeah, it's extremely uninteresting to talk about from their standpoint, right? But
yeah,
what indemnification is what it was designed to do was to protect an innocent party from third-party suits. So, for instance, let's say you sell a piece of capital equipment to a company, and part of your agreement is that you will go and you'll supervise the installation of that piece of equipment.
Okay.
Means you're going to be on site, right? You're not actually installing it, you're not providing the service, but you're going to be there and you're going to be supervising the installation to make sure people aren't doing anything that they're not supposed to be doing. Mm-hmm. So let's say somebody gets hurt and it's the fault of the company to which you sold the piece of capital equipment. But the guy that got hurt, their lawyers are going to make sure he recovers. They're going to sue everybody. So you get sued as well as the company that you sold the equipment to. Well, what indemnification was meant to say is that, look, if it was my fault, if my negligence and my supervision is what caused this injury, then you shouldn't be getting sued for it. So to the extent you are, I'll pay for that defense and I'll pay for any liability that the court assesses to you. Conversely, if it's your fault and I also get sued, you'll do the same for me. You'll pay for the defense, you'll pay to get me out of the lawsuit, or you'll pay any damages that are assessed against me. Mm-hmm. So that was the purpose.
Yeah.
What's happened now is that companies are using that provision. They're expanding that provision to cover all kinds of new liabilities and new issues. So, for instance, they now want you to be responsible for any breach or anything related to the equipment or anything. In some cases, they'll actually ask you to indemnify them for their own negligence, meaning they were negligent, they caused it. They still want you to pick up the fees and the cost and pay for it.
Wow.
And then that one, of course, you chuckle at a lot, but that's actually unenforceable in close to half the jurisdictions out there. So, the law recognizes that that's a pretty absurd thing as well. Yeah. But at this point, the law only recognizes that in around half the states. Many other states still will enforce those type of provisions. Wow. One thing that's important about that specific provision and some of the other ways to word that form of liability is that many times it's not insurable. So, you're a business, you understand that there are certain risks, that there are things that happen, that sometimes people get hurt as a result of your employees' actions or your products. And so you buy insurance. That's why you have insurance, to cover those things. Mm-hmm. And you feel like that insurance will cover you. But if your indemnification is, if you agree to indemnify for their negligence, if you agree to indemnify for acts or omissions or performance under the agreement, then you're taking a chance that those things are not insurable. And so you may get this claim for indemnification that may reach into the 7 or 8 figure area, wherein your insurance says, well, I'm sorry, but we've agreed to insure you for personal injury or property damage due to your negligence. Outside of that, we do not insure you.
Yeah.
Now, practically speaking, the people that you're contracting with, that's probably all they want is access to your insurance. Mm-hmm. They're probably happy if they have the benefit of your insurance for personal injury or property damage that you caused or that is due to your negligence. That's probably enough. Mm-hmm. But their lawyers have drafted their documents in a way that is intended to give those lawyers an upper hand to the extent there's ever a dispute. So as an example, an indemnification clause will say, you agree to indemnify for acts or omissions related to the performance of this agreement. You agree to indemnify for your negligence, your willful misconduct, and your fraud. You agree to indemnify for things related to the performance under this agreement, various things like that. Well, your insurance is only going to respond to a claim that's for personal injury or property damage due to your negligence. So if it's submitted as a claim for willful misconduct or fraud, if it's submitted as a claim that's based on an act or omission, but not necessarily a negligent act or omission, you're taking risk that your insurance won't respond. At the very least, you're putting yourself into a position where you might need to now litigate against your insurance company. You might need to fight against them. Okay. And practically speaking, how it really works, because again, remember at the beginning, we talked about a lot of times this is with your customers.
Yeah.
You don't want to sue your customers. You don't want to be sued by your customers. You absolutely do not want to end up in court with your customer because typically that makes them your ex-customer. And so really what we're talking about is leverage. And if they can tell you, look, I have the ability to file this claim against you. I'm going to sue you for negligence. I'm going to ask for indemnification for negligence. I'm going to ask for indemnification for your willful misconduct. I'm going to ask for indemnification for fraud. I'm going to submit 7 different claims, 1 or 2 of which your insurance might agree to respond to, the rest of which you're going to have to respond to yourself. So rather than running up a 6-figure or 7-figure litigation bill, why don't you just pay me some number, just below that?
Yeah.
And now you're in a situation where you have to make the decision, even if you feel like you're in the right, even if you feel like you would ultimately win the case and that it wasn't your fault, you have to make the extremely unpopular decision of either paying them what they want in order to preserve the relationship and avoid the risk of spending all that money on your lawyers, or you have to agree to fight it and take on that liability, knowing your insurance company isn't necessarily going to pick up the tab.
Yeah, I mean, that's all, going back to what you were saying with terms and conditions too, it sounds like it's to backtrack, that's going to be a heck of a lot more costly for the company than to just take the time, and hire on somebody to help them write out their agreements. So then that way, you are covered if anything does pop up. You don't have these 6, 7, maybe even 8-figure claims coming at you.
Well, yeah, and there's there's different ways to do it. If you're big enough and your orders are big enough, you can control the process. You're sort of the big fish in the transaction, if you will. A lot of times, you'll be able to be the one to dictate terms and conditions. Hey, if we can do this transaction, but it's subject to my terms and conditions, not yours. Mm-hmm. And that involves some upfront review, making sure they match with how you do business, and then tailoring them to eliminate the ambiguities. And that's one of the main things that I'm looking to do. What you find, especially with Fortune 100, Fortune 500 companies, their terms and conditions, their documents, they're drafted by litigation courtroom attorneys, mm-hmm. Which I'm not. By the way, I'm a transactional guy. I spend almost no time in court.
Okay.
But typically they're written by litigators, and they're written in a way to give these litigators the advantage when they're in court.
Mm-hmm.
And that's the goal. Hey, if we end up in court, we end up in a dispute, I want to have these advantages. I want to have this vague language that I can exploit. I want to have this language that doesn't sound terribly damning, but due to case law in this jurisdiction is extremely important to me and gives me huge advantages in litigation. That's their goal.
Yeah.
As I tell my clients, my goal is to make sure you never end up in court in the first place.
Yeah, definitely.
And the way you do that is you eliminate the ambiguities. You make sure that everything is clear. You take away their ability to argue that what you think means A actually means B. Mm-hmm. More importantly than that, though, my job is to remove the ambiguities, make sure that you understand that both sides agree on the meaning of a term, that those arguments are not there, that they don't have the ability to argue that what you think means A actually means B. Mm-hmm. But more importantly, it's about limiting and reducing the size of the target on your back. This is something that I do training for several of my clients in this space, and oftentimes I'll train their sales staff to sort of allow them to understand the benefit of this as well. Because the salesmen are saying, well, why are we messing with this? Just sign the document, pay me my commission. Yeah. You know? But part of what we're doing is we're trying to take away their ability to have leverage over you in the instance of a dispute. So we do that, one, by eliminating ambiguities and making sure that everyone understands that they don't have arguments about the document. But two, we do it by eliminating places where they can try to have advantages from you, such as indemnification, places where they can threaten 7-8 figure liability that may fall outside of your insurance. So one of the main things is limiting that indemnification to the insurance. And when you tell a business guy, look, you'll have access to my insurance. If anyone gets hurt, if anyone dies, if there's major property damage, to the extent that it's my fault, meaning due to my negligence, you will have access to my insurance, which stretches into the millions of dollars. To the extent that you need more insurance, let's talk about that, and we'll decide if we can buy more insurance and potentially build that into the cost of the product. Another thing we do is by limiting the liability. Avoiding consequential damages, for instance. You'll see in just about every contract out there nowadays a limitation of liability that'll say, in no instance will such and such party be responsible for consequential, special, punitive, indirect damages of any kind. And that eliminates an entire category of damages that ultimately can bring down a company. So, for example, let's say that you're delivering a product to some kind of a food producer or someone that produces goods for consumers. And you're delivering a piece of capital equipment that you manufactured, and it's going to go on their line somewhere. Well, turns out you're 4 days late on your delivery. And so they come back and they say, well, those 4 days you were late, we had to shut the line down. We didn't run this line for 4 days. Mm-hmm. Every day that our line runs, we produce $1.5 million worth of product. So that's 4 days at $1.5 million a day. We were unable to produce products. So we want you to pay us the $6 million in lost income. Yeah. Now, the legal standard for that is proximate causation, meaning if they can prove that you were the proximate cause for that loss, you are responsible for it. And in this instance, they probably can, right? Everything was fine. We were supposed to have the piece of equipment on this day. It didn't get here. Therefore, it didn't get here till 4 days later. Therefore, we missed out on those 4 days. Mm-hmm. And, maybe you just sold them a $100,000 piece of equipment and they're asking for $6 million in consequential damages, and your insurance company is telling you there's no coverage. Well, did you realize you were taking on that much liability? Did you realize that was a possibility? Probably not. No, I don't think that there's too many people out there risking the viability of their company for any order. Mm-hmm. And so, practically speaking, then, when you're negotiating these documents, the other side understands that. You say, look, I understand that you want this to be there on time. You want me to perform all these type of things. However, there are certain things that can be out of my control. This is especially a problem for distributors, by the way.
Yeah.
And frankly, if I'm in the position where I might have to pay consequential damages, those get into the 6, 7, 8-figure range really fast. I can't sell you this product for anything, really. I mean, I can sell you a $100,000 piece of equipment for $4 million, maybe. This is the kind of liability I'm taking on.
Yeah, exactly.
But, your reaction shows how ridiculous that is, and it's not going to work. And so, that's another really important thing that oftentimes people don't realize the importance of or understand until they get that phone call from somebody telling them to pay them for their lost time or their lost profit. And it's stretching into the level that's catastrophic for their company.
Yeah, and that'd be a little bit eye-opening as well. Maybe for a salesperson made the sale, they got their commission, but you may be paying that commission back plus some if you just kind of rewrite the contract just to get that sale.
Absolutely.
So you had mentioned earlier, some different insurances and things of that nature to kind of benefit and safeguard some manufacturers. I know you mentioned briefly about the employment practices liability. Can you speak on that a little bit more? Maybe how that helps benefit manufacturers or safeguard them?
Sure, absolutely. Employment practices liability insurance is something that a lot of my clients are investing in and looking more into nowadays, especially if you have high volatility, high turnover, if you have seasonal work, times where you have to staff up and other times where you have to scale back. Essentially what it is it's insurance that protects you against various claims for discrimination, typically in firing or not promoting or those type of things. Any kind of litigation that things that your employees could potentially sue you for, which typically does come down to some kind of discrimination or unfair practices.
Yeah.
And, typically what we'll see, most of your customers will tell you, most of my clients will tell me that they're not out there firing people for improper reasons. Obviously you can't fire someone because of their gender, because of their religion, because of their, sadly you can fire them because of their sexual orientation in many jurisdictions, but
really?
There's several things that you cannot fire them for. Very rare that my clients will say, "Oh yeah, we did something wrong here. We shouldn't have done what we did. This supervisor went rogue and shouldn't have done what they did." Typically, it's this person's upset that they were fired, and now they went and got a lawyer, and now we're being sued. So the way that progresses is every state's different. In some states it's really easy to get into court with these type of claims. In some states it's a little bit harder. And what I mean by get into court is that you have a stage of all litigation that we refer to as the summary judgment stage, which is essentially where one side can say, "Look, Your Honor, even if everything that the plaintiff is saying is true, we have no liability. We still didn't break any laws, and here's why." So even if everything's proven true, they're still not going to win. And if the court agrees with that, they'll dismiss the case, and it probably didn't cost you a ton of money at that stage.
Yeah.
However, if the court says, well, maybe if they are able to prove that fact or that fact, then you would lose, you would have liability. And so I'm going to allow this to go to trial. Well, to the extent that they are less than meritorious claims, the attorneys on the other side, who are typically working on commission, again, these are individuals, not companies, that have been fired. So oftentimes they don't have a lot of money to pay their attorneys. So the attorneys are usually working on commission. And what the attorney knows is that, look, this is going to cost you $50,000, $60,000, $70,000 to litigate. Why don't you pay me $20,000 and I'll go away?
Yeah.
And if they can get the judge to say, yeah, this is not going to be thrown out on summary judgment, there looks like there could be something here, we're going to trial. Well, now they've really strengthened their position, because now the company has to make the decision of whether they want to spend $50,000 and win, or $20,000 and lose.
Yeah.
Meaning just write the ex-employee a $20,000
just
check.
to make it go away pretty much.
Right. So you can imagine that's not a good decision. Nobody wants to be put at making that decision. Nobody wants to give their ex-employee who they feel they treated fairly and didn't do anything wrong with a big payday just for bringing a lawsuit. But at the same time, you don't want to spend 2.5 times as much to litigate it, even if you think you're going to win.
Yeah, and that could set a bad precedent for, future employment that gets kind of laid off or fired. So-and-so got a case out of it in settlement money. Let me try to do the same thing.
Exactly. And that's oftentimes why people choose to spend the $50,000 to win instead of the $20,000 to lose. Because if word gets out, then everybody who gets fired is going to be filing a lawsuit.
Yeah.
Try to get that money out of you. So
exactly.
In steps, employment practices liability insurance. Not only will that pay for any kind of damages that you're assessed. So if it turns out the judge says, yes, you did fire this person improperly, it will pay for that. But more importantly, in this context, it pays for the defense. So imagine this scenario we've been talking about. You've got your plaintiff's lawyer. Somebody came into their court and said, hey, I was fired. I'm a female and I was pregnant at the time. That's they love those cases are fairly easy.
It's kind of a double whammy.
Yeah, there's a lot of protections. There's a lot of laws in place, and frankly, there's a lot of history of employers, mistreating pregnant women. So there's a lot of things that fall into play there. But maybe that plaintiff's lawyer deep down doesn't think they have that good of a case, but they know they have a woman who was fired when she was pregnant, and that's oftentimes enough to get you into court. Mm-hmm. Well, they call and they say, look, we're suing you for this. We'd be willing to talk settlement to avoid the lawsuit. Let us know if you want to talk settlement. And you say, well, okay, I'll review when the lawsuit comes in, or when I get the subpoena, I'll turn that over to my employment practice litigation insurance carrier, and they're likely going to be the ones to handle the defense. So send it on over, and we'll put you in touch with the proper attorneys that are going to defend this case. Well, what you've just told them is that they have no leverage against you to get a sort of quote unquote blackmail settlement out of you. You're not paying the bill. Your insurance company's paying the bill. So guess what? If I'm on the better end of that, let's go to trial. I want to go to trial and win because I'm going to win, and my insurance company is going to pick up the bill, not me. Yeah. So suddenly they don't have that leverage. And now from that plaintiff's lawyer standpoint, the calculus has just changed for him or her. Yeah. Before they thought, well, I'm going to make 35%. If I can make a few phone calls, posture a little bit, and get this person 20 or 30 grand, I'll get a few bucks and it'll be worth my time. Mm-hmm. Well, now all of a sudden they're up against an insurance company. That means they actually have to have some merit to their case. They have to have a lot more confidence that they're going to be able to take it all the way to the mat and win the case on the merits themselves, which oftentimes is not easy, considering that in most instances you have the right to fire someone for any reason other than a protected reason. Yeah. So we talked about leverage earlier. A lot of it is about leverage, and companies don't have to spend a lot of money on the front end to properly position their documents, to properly insure themselves, to make sure that they're protected against these kind of things, and ultimately to just take the leverage away, because that's the way the law works these days. 90+%, I think the stat that I last heard was something like 98% of cases get settled and don't go through trial. So it's really about gaining leverage and posturing for leverage. And that's why so much money gets spent in the discovery process of lawsuits, because what you're doing is you're trying to find that evidence. And as soon as you find that damning evidence, you use that to leverage a bigger settlement. And so that's part of what we're trying to do is take that away. And actually along those lines, story I was going to tell that deals with what we call battle of the forms.
Okay, yeah, I was actually just going to ask you about this because I found it interesting when we were in Arizona when you were telling me about it, about kind of terms and conditions is not necessarily a purchase order agreement. But if you want to speak a little further to that for guests.
Yeah. So when it comes to contracting, you have the law has three basic concepts: offer, acceptance, and consideration. If you have those three things, you have a valid contract. Okay. So how does this work in practicality? Well, maybe you send a quote to somebody and you say, here's what I can sell you and what I can sell it for. This is my offer. And the other guys can come back and say, I accept that offer. And the consideration is, I'm going to pay you X amount and you're going to deliver me this piece of equipment or these parts. So we have a valid contract. Practically speaking, though, that it typically doesn't go that way. So I'm going to give you an example. Had a client, this was from before they were a client, sort of one of the things that probably drove them in our direction, but this is a client that sells capital equipment, basically.
Okay.
And they had provided a quote to a major Fortune 100 company, and they'd said, we'll sell this piece of equipment to you for $500,000. Our terms and conditions apply to this quote, and here are our terms and conditions. It's got your warranty, your liability, your insurance, all the different provisions that we require, and they're attached to this quote. Mm-hmm. So this company comes back and sends them a purchase order. We accept, we would like to buy that. Oh, but by the way, our terms and conditions apply, not yours. So to the layman, they've accepted the offer. To the lawyer, they've provided a counter offer. Mm-hmm. Because we said, we will sell you this piece of equipment under these terms and conditions. And they said, well, I'll buy it, but not under those terms and conditions, under these other terms and conditions. That's why we call it battle of the forms. You sent their form, you sent your form, they sent their form back.
Okay.
Well, what they've done there is they haven't accepted your offer. They've made a counter offer. And now the ball's in your court. So now if you take that purchase order and say, I accept, well, you've agreed to their terms and conditions. Okay. And the fact that you quoted it with your terms and conditions goes out the window.
Yeah.
Conversely, if you just start performing, and that's what happened in this instance, we sent a quotation saying our terms and conditions apply. They sent back a purchase order saying their terms and conditions apply, and we went ahead and processed the order, sent them the equipment, got paid, all that good stuff. Mm-hmm. What we had done is we had accepted their order with their terms and conditions. But of course, the client didn't know about that. He was not a client at the time. They were not engaging counsel of any type, to my understanding. Fast forward then 3 years later, and there's a problem with the equipment. It's doing something that we hadn't anticipated, they hadn't anticipated, but it's not working properly. So they call us up and they say, this isn't working properly. We want our $500,000 back. Come get your equipment. Give us a check for $500,000. That's what we want.
Yeah.
So I get the phone call. Well, do we have the ability to do it? What is he talking about? I sent it over. Our warranty was 1.5 years. Can't I just respond to this to say you're out of warranty? Sorry, we don't have the requirement. We'd like to help you. Again, this is a customer, right? Mm-hmm. You're not just going to tell them to get lost.
Yeah.
But you also don't want to feel like you are on the short end of the leverage stick and that you ultimately have some requirement to pay them $500,000. Mm-hmm. So I said, well, the problem is that you may have sent the quote with your 1.5 or 1 year, 2 year warranty, whatever it was. When they returned it, they sent their own terms and conditions, and their terms and conditions included a warranty section, and their warranty section did not have a definitive timeline on it. And so we have to go to common law, or in this case, the UCC, to determine what the warranty period the law would likely put on that. Because if you don't say there's a warranty period, it doesn't mean you're warranting your product till the end of time.
Yeah.
But the UCC, the common law, would say that it's basically a 4-year warranty.
Okay.
And so here we are thinking we're providing this product with a 1 year or 2 year warranty, but because we performed after receiving their form and their terms and conditions, we actually accepted theirs with a 4-year warranty. We didn't charge them any more money for that. Yeah. And I can't imagine you have a single customer listening that somebody said, hey, we want you to triple the length of your warranty. Many of them are just going to say, no, I can't do it. Warranties are designed to, go about as far as they know they can go. And, they're not expecting any flaws or defects within that time period. That's why they set it the way they do.
Yeah, and if they do expect one, that's probably beneficial for them to figure out how to, better improve it moving forward if they see a lot of those claims within that time period.
Yeah, exactly. I mean, obviously that'll impact their sales and whether they're selling more equipment, those kind of things. But, at the very least, if someone's asking you to triple your warranty period, you're going to want to get paid for that. You're going to charge more.
Yeah.
But of course, that didn't happen in this instance. So the battle of the forms is a real tough one, and I'm sure it's something that your listeners see all the time because it's extremely common.
Yeah.
That people, everybody wants to use their own terms and conditions.
Well, that's why companies offer extended warranties at a price. It's not you can extend the warranty out, that's fine, but we're going to gain some money from it because that's obviously extending our liabilities and potential for having to replace it 5-10 years down the line.
Yeah, that's right. And that's one of the things when I'm training the sales forces of these various clients is I try to impress upon them that, look, you're not just selling this bag of parts or this bag of goods or this piece of capital equipment. You're selling everything as one bundle. So this is a bag of parts along with a bunch of terms and conditions in it. And you're saying, I'm going to sell this to you for X amount of money, for, $100,000. I'm going to sell you these parts on these terms and conditions. Well, if they come in and say, hey, put another 100 parts into that bag before you sell it to me, you're going to say, okay, but I need to adjust the price. Of course you're going to say that. Every business on the planet will adjust the price when they're putting in more product. Well, it needs to be the same, or the mindset needs to be the same when we're talking about terms and conditions. Well, I agreed to sell you this product for $100,000 based on the idea that indemnification would be limited to my insurance. There would be no consequential damages of any kind. That delivery would be on a best efforts basis, whatever these terms may be.
Yeah.
Well, now you're coming back and asking for, and a 1-year warranty. Now you're coming back and asking for a 3-year warranty. You're asking me to accept liability for indemnification that my insurance won't respond to. Mm-hmm. And you're asking me to be liable for consequential damages. Well, that massively changed my risk profile. The bag just got a lot bigger. You're asking for this bag of a ton of stuff. And so one of the things that I'll say is, you can let them know that we can accept any terms and conditions. Theoretically, any terms. You want me to accept consequential damages? Fine. You want me to take on liability for things my insurance won't respond to? That's fine. But I'm going to need to reprice the product. Mm-hmm. That $100,000 worth of parts just became $2 million worth of parts. Do you still want to buy them?
Yeah, exactly.
No? Okay, well then let's talk about how we can get that $2 million price back down close to the $100,000.
Yeah.
Do you really need to be able to put me out of business if something goes wrong, or do you just need my insurance? Mm-hmm. Well, I just want to know that I can go to your insurance, and I want to know that you got at least $5 or $10 million worth of coverage with an umbrella policy. Great, fantastic. I can give you that. The price just came way down.
Yeah.
What about consequential damages? Can you, worry about managing those type of things a little bit more on your own? Can we come to an agreement about how this will look so that you don't face those kind of damages? But can we at least say that to the extent they are, we're not going to be responsible for them? Sure, absolutely. That almost never happens. There's things we can do if you deliver a little bit late. We just want to be able to know as soon as you find out you're going to be late, we need to be able to know immediately so we can plan accordingly. Yeah. Great. We'll make the language say that. We'll waive consequential damages. Now we're back to the point where we can sell you this for $100,000.
Yeah. Yeah, it's definitely a lot to think about, but something to keep in mind. Always pay attention to those terms coming back at you and don't necessarily act on them like it's a purchase order.
Well, and another thing that happens is people are oftentimes, depending on the nature of what they're selling or who they're selling it to, one of the things that's happening to a lot of my clients is they're essentially being treated like subcontractors. Mm-hmm. They're supplying goods, but they're supplying them to an EPC who's building a power plant or a wastewater treatment plant or some other type of major construction project. You're supplying some part to it, but they're sending you the same contract that they're sending their electrical subcontractors who are going to be on site running wire, doing those type of things. And they're expecting you to take on similar liability, or they're at least keeping all those terms in there. And so what happens is people will sign them and say, oh, well, none of that stuff applies to me. So I can sign it, because if they ever come back to me and say, well, what about section 14B? I can just say, well, I'm not a subcontractor. I'm just a supplier of goods. And so that doesn't apply to me.
Yeah.
Problem is that's not how the law sees it.
Yeah.
So your
language is written.
Yeah, you're in court, you have a dispute, and the judge says, well, what does section 14B mean anyway? What did this mean you're supposed to do or supposed to have done? You say, well, Your Honor, that clause means nothing. It means nothing. It doesn't apply to me.
Yeah.
And, okay, well, then why did you leave it in the document?
Yeah.
Well, I didn't want to ruffle any feathers. I didn't want to, add to the process of negotiating this document, so I just left it in there. And he said, well, guy on the other side of the table, what do you think it means? Well, Your Honor, it means X, and it means they had to do X, Y, and Z, and they didn't do any of those things. Therefore, they're in breach. Therefore, they must pay me X amount of dollars. Well, a judge is not going to be convinced that you left language in a contract intending for it to mean nothing.
Yeah, exactly.
If it's in there, the law is going to try to give it meaning. And so that's another major flaw I see with people that will sign these 20-page subcontractor type agreements, thinking that really this stuff won't matter. But when something goes wrong with the project and the general contractor or the EPC or whoever it may be is trying to recover and trying to cut their losses, they don't care who's responsible necessarily. They care who they can get money from, who left me gaps, who's got the biggest target on their back. That's who I'm going to talk to. That's who I'm going to try to get money out of. And so that's another important thing as well, is to not be signing agreements assuming that language has no meaning. Every word in the document that you sign has meaning, and the court will try to find a way to give it meaning every single time. And again, that's why I say these are drafted by courtroom litigators. Oftentimes, they know why they put that language in, and they know why they're, why it sounds inapplicable. Is because there's other cases that say when it says this, it means this. Well, if you haven't, involved an attorney or at least tried to get rid of those type of terms, you're not going to know that until it's too late, till they're calling you and they have all the leverage, and you're stuck having to pay them for something that may not be your fault.
Yeah. I mean, I get the kind of the terror on that is, I want to get this business. I want to get moving on this contract and win it. So I don't necessarily want to have this going back and forth and wasting valuable time on the process of manufacturing it. But at the end of the day, I mean, if it means going back and forth and getting terms that are hammered out that aren't going to kill you in the long run, I mean, it's, in my eyes, and I think a lot of the listeners' eyes, it's totally worth the time not to start that manufacturing process until you know for sure that you're covered.
Well, yeah, and you can, a lot of people have repeat customers, so maybe you only have to do this one time, and then you say, look, all future orders between us are based on these terms and conditions. So a lot of times, I'll get involved for one negotiation or one redlining or whatever it may be, and then the companies will go on doing business for years and years. They'll just do it based on that, the one time they negotiated those terms and conditions. Yeah. And they know they're protected. They know their insurance is going to respond. It really strengthens the relationship as well, because frankly, imbalanced relationships can be problematic. If the other side, if your customer or your supplier holds all the cards, has all the leverage over you, you're not going to get the efficiencies that you otherwise would get. You're not going to get the economies that you otherwise would get. And so, that's important as well. Yeah. And it's not like these companies don't expect it. There's also a certain respect level that you get. If you're just signing any document, that says something different about your company than if you're taking the time to protect and consider the ramifications of signing just any old agreement.
Yeah. So, kind of this is going into my last question that I have for you today. What would you say or, kind of suggest for our listeners to do to kind of take those steps moving forward to make sure that they're covered either contractually or, with their terms and conditions?
Well, typically the process that I follow for a new client is we first look at their own terms and conditions. So now take a look at your terms and conditions. Read them, make sure it sounds consistent, make sure the terminology is consistent. Most of all, make sure that it's consistent with how you actually do business, because you'd be surprised how often people say they'll give me their terms and conditions, and I'll ask them a question about it and say, well, so when you do this in respect with your quotation process, or when you ship the products in this way or whatever, oh, we don't do it that way. We do it this other way. Okay, well, your terms and conditions say you do it this way, so let's address that. So you start with your own terms and conditions, and oftentimes, I have customers that'll say, look, if you're wanting to order $10,000 or less worth of product, you do it on our terms and conditions. If you won't do it on our terms and conditions, you can find that product somewhere else. Now, if you're wanting to buy $50,000 or somewhere over $10,000 or whatever the threshold is that you set, then we will negotiate terms and conditions with you. And whether you end up getting outside counsel involved for that or not, typically you would, they can then job cost that in. So that's what a lot of my customers do is, we'll first get their terms and conditions in order, and we'll say, look, we know you're comfortable with this. You can take any order based on your terms and conditions. You're going to be protected. But then also, and so to the extent you haven't had them looked at by your attorney or by outside counsel, you want to do that. I mean, every person that is out there listening, every company is a little bit different. I represent small fabricators that are 5, 6, 7-man shops. I also represent huge manufacturers that supply all over the country into Canada, major capital equipment, distributors of parts, things like that. So they all have slightly different issues, slightly different points of leverage. My 5-man fabrication shop, their terms and conditions can't be quite the same as the $100 million company selling capital equipment. So there's, it's not a one size fits all thing, I guess is what I'm saying. But you want to start there, start with your own terms and conditions, and then maybe go back and look at some of the documents that you signed, especially if you've just order came in, I signed it, I didn't read it. Take a look at that with your attorney or with your outside counsel, and or at least someone who's experienced in this type of work, and have them be able to advise you on, okay, well, here are the pain points. Here are the places where they have advantages over you. Here are the things your insurance won't respond to. Here are the places where you're, allowing for things like consequential damages, whatever the case may be. So some of it is just about getting that education and that understanding. And then ultimately, for the majority of my clients, when the orders get to a certain level, if the company will not use their terms and conditions, they'll send those over to me and they'll say, provide a red line, and we'll negotiate them. And again, a lot of times you only have to do that one time with a customer. You come to an agreement and you move forward on that set of terms and conditions, until somebody has an issue or until the law changes or whatever the case may be. And I've negotiated dozens of those on their behalf. And that can usually work really well. As it turns out, working with the really large companies, the Fortune 100 companies, Fortune 500 companies, really large engineering firms or EPCs, they can sometimes be more difficult to work with.
Because too many different legal counsels that they've dealt with.
Well, there's a lot of moving parts. If I can get the CEO or the owner of a company on the phone with the decision maker for my client, we can usually hammer these things out pretty good because they're business people. They're not concerned about having an upper hand in court. They're not concerned about being able to exploit provisions, in a way that will give them legal advantages. They're concerned with doing business, buying the equipment, selling materials, whatever it may be, whatever they may be positioned in the transaction. And so, they're not looking to get these advantages. The larger companies, they're very layered, right? So the first person you're talking to has almost no authority to do anything.
Yeah, gatekeeper.
They're kind of annoyed by the idea that you're going to provide a red line that their lawyers now have to look at. But their lawyers are buried in some room somewhere that you don't really have much access to them. And so you're constantly doing the he said, she said. Well, this is what we need. Our lawyer said no. Okay, well, can we talk to the lawyers? Can we ask why? Well, no, nobody can talk to them. Okay, well, what about your boss? What about your boss's boss? Can you get to the decision maker who can say, okay, we don't need these things that my lawyers think we need. We just need X, Y, and Z. We need access to your insurance, those type of things. So it can be more difficult to work with the larger companies like that. But it doesn't mean you shouldn't try, because frankly, those are the companies that are most on top of this. Those are the companies that are sending out new versions of their purchase agreements 2-3 times a year. And they're doing so because they're responding to typically legal issues or legal problems that have arose.
Yeah.
And so, over time, you're probably exposing yourself more and more, even if you're working with the same type of companies, the same company that you've been working with for years.
Mm-hmm. Yeah, I mean, is there, so I know I said that was my last question, but that brings up another one for me. Is there like a time frame that you would suggest, kind of go back every so often or every couple of years to verify that your terms and conditions or, anything that's written out contractually is still abiding by current laws?
Yeah, I mean, it doesn't hurt to have them looked at every couple of years. The law is not extremely dynamic for these type of things. Again, typically the law is going to assume that businesses are sophisticated parties and they're going to try to stay out of their way. Of course, things do change. Part of the art of drafting terms and conditions is to not get overly specific about specific regulations or laws. Most of my clients are very comfortable saying that they will abide by all laws or all applicable laws without having to go in and say, here are all the laws we will abide by. So, it definitely doesn't hurt, especially if you're not someone that engages counsel often, or you don't have attorneys helping you negotiate these type of things. It certainly doesn't hurt to have them looked at every couple of years. I also think that training is an important aspect to the extent that you are going to negotiate these type of things. It's important for your sales staff to understand why you're doing that. And that just getting the sale, if you're risking the company to do so, is not going to be in the company's best interest, and it's not going to be the kind of thing that you can allow your salesman to do. And so making sure there's an understanding throughout the organization is important as well.
Okay. Well, cool. That's all I had for you, Aaron. I don't know if there's anything else that you wanted to speak to before we wrap this up, or pretty much hit everything on your list.
Yeah, I think we covered everything I wanted to talk about. I think the main thing to take away from it is just to take a few minutes to look at your terms and conditions and make sure they line up with how you do business and your expectations. Look back at some contracts. If you have outside counsel, ask them about these type of things. See if they negotiate these type of agreements, or if they have someone that understands this space. Obviously, I'm happy to answer any questions that any of your listeners may have, or to look at any of their contracts or documents, or provide any kind of education or those type of things as well. Because again, I don't know the nature of all your listeners. Mm-hmm. If you're 2 or 3 guys in a brand new fabrication shop trying to get off the ground, your needs are a lot different. You're probably just going to want to get a good set of terms and conditions initially, and then have somebody that you can call and refer to. Mm-hmm. If you're a company that's supplying, hundreds of thousands of dollars worth of product, or if you're supplying major capital equipment or those type of things, you probably already have, an attorney involved, and to the extent they understand the nature of these things and they're a business-minded attorney, then you want to ask about them.
Mm-hmm. Yeah, and we'll have your information out on the description of the podcast as well, with a link to your page, email address, and phone number as well. So if anyone's got any questions, just look in the podcast description, and you'll be able to find Aaron's contact information there. The Lantec Link podcast helps link manufacturing professionals with industry experts, providing news and insights regarding technology, education, and the economy of manufacturing in the U.S. This podcast will answer questions manufacturing professionals may have about Industry 4.0. If you would like to suggest a topic or be a guest on our show, please email Kevin Must at k.must@lantecsms.com.